Alex here with a legal nuts and bolts video on stare decisis. This is a Latin phrase which means to stand by what is decided. It is the doctrine that controls lower courts by forcing them to adhere to established precedent, which is basically case law. It's published case law. It might extend to unpublished cases in some states. It really depends. And even then, it's usually not mandatory. It's usually persuasive. I think that's what it is in Nevada anyway. Stare decisis itself is a doctrine that explains to judges, both lower judges and appellate courts, that binding precedent is binding or mandatory. It's not optional. It must be followed. Precedent, as I mentioned earlier, is basically case law, and eventually people will reach the point where they realize case law changes sometimes. Why does that happen? That happens because stare decisis does have its limits, and it's a little counterintuitive, but if you want to figure out what it's going to take to get a lower judge or an appellate court to disregard existing case law and basically rule that your idea of what the case law should be changed to is correct, you actually do need to look at stare decisis, because when you look into that key phrase, you will not find just explanations as to this is binding precedent must be followed, but you'll also find cases which discuss the exceptions to it and how to get an appellate court or a trial court to disregard precedent. From what I've seen, there is two really kind of out there statements that are a little obvious, and I'm still going to go ahead and read them. I think people would already understand this, but I do want to sort of go towards accurately figuring out where the line is on when you can get a court to disregard existing precedent. But I'll just go ahead and go into those two statements that I've read. The first one is, blind adherence to the requirements of stare decisis is not consonant with justice. And again, it's kind of obvious. Nobody thinks that you should just blindly adhere to case law, to precedent. You should look into it and see if there are reasons as to why it doesn't apply. The other obvious statement that I saw had to do with the common law specifically, and so I've seen stare decisis used in slightly different contexts. In the one hand, it's for dealing with precedent that is based on statutes, rules, and case law. On the other hand, on statutes and rules. On the other hand, it's got to do with common law. And for that one, again, another obvious statement. It was the doctrine of stare decisis must not be so narrowly pursued that the body of the common law is forever encased in a straitjacket. Again, this is something that I think most people would understand. So, as promised earlier, I did want to go a little bit more into some overarching general ideas as to what is behind when precedent isn't followed. And I think I just want to start with the easier one first, which is statutes and court rules. Typically it's statutes. Sometimes a statute will change. Sometimes a new statute will be created that will set forth a policy that might clash with an existing policy. Sometimes the intent of the legislature, which was clear before, becomes a little bit more complicated or murky now because of some new law that was created. And when you have precedent that's based on interpretation of statutes or court rules, and you have statutes that change, that's the obvious thing. If the statute is changed or repealed, obviously that wouldn't apply anymore. But sometimes it's not that simple. Sometimes new statutes are created and things get ambiguous, and so the stare decisis doesn't really hold up when the underlying purpose or the underlying premise as to why that decision came out is no longer, it's either completely gone or it's no longer clear and takes a second look now based on the new rules or the new statutes that have passed. So one of the ways that you can get a court to disregard stare decisis is to say, look, new statutes were created and these conflict with the ones that existed prior, and so a new analysis on that case, that previous case that established precedent, should be conducted now because maybe that precedent isn't any good anymore. One example I recall recently that came up in Nevada had to do with retirement. there was a whole lot of binding precedent or case law on how to deal with a spouse who wants to continue working and not retire, and another spouse who's claiming, hey, that's injuring me. I need them to retire so I can get my portion, my, what do they call it? My community property. It's something, a portion of community asset or community property, something like that. They want to get their portion of a community asset that was divided, community property that was divided, their share of it, and they can't get it because person's not stopping. They continue to work, and since they haven't retired, they can't get access to that money. And that there was a whole lot of case law on it that came up, and I read a case where the Supreme Court responded after reading both briefs from both sides. Hey, this new law was created years later, years after that precedent was established. So the Supreme Court said, we want both of you to file supplemental briefs with an explanation as to how you think this new statute may affect our previous decisions, our previously established precedent. That doesn't usually happen. I think usually the Supreme Court just makes a decision and that's it. But every now and then, sometimes they will really want to get to the bottom of an issue, and they'll enter an order like that saying, hey, we want some more briefing because we want this question answered, and you guys didn't talk about it. So there's a new statute here. It may affect our precedent from prior. And anyway, that's the idea with stare decisis surrounding statutes and rules. It's basically you saying we shouldn't follow that anymore because we have a new rule. There also might be other complications that occur, like maybe the rules or statutes don't change, but some new constitutional interpretation comes up. And based on how the Constitution is being interpreted now, this particular statute now is at risk of not being constitutional. And so you could be creative with it. The point is, if you want to look into how it works, stare decisis is the magic phrase. Those are the key words that you would look into to figure out how to get around established precedent. And it's not always something that can be done. I think there's even some mention in the case law. You can't get stare decisis to be disregarded just because you don't agree. That's not enough. It's not even close to enough. Not agreeing, that's just you. That's your personal opinion. You have to really do some analysis on the decision itself, where it came from, what kind of new stuff has occurred, etc., etc., etc. I think a lot of people think that this is mostly just a thing that happens when new people get on a Supreme Court and so they just change their vote. But my understanding is that that doesn't occur. Usually, I'm sure there were times in the past when certain things were just egregious when certain things were considered normal way back then, and now things are considered egregious, and well, let's just do another decision on it, and just since there's more of us or on one side, we can just outvote the other and change everything. I'm not sure how often that happens. In fact, if anyone here has any insight on that, that's something you might want to put in the comments. Maybe we can all learn about that a little bit. But from what I have read, that's not even close to typically how it occurs. The other part is a little bit more complicated, is how they apply stare decisis to common law, to precedent that comes from common law or interprets common law. And I'm just going to go ahead and read from a case to sort of, it's a lot less clear, but here's what they say in a Nevada Supreme Court case. I'll go ahead and post a link to it in the comments below. It's an old case from 1974, but I think it gets the point across. They basically say that one of the great virtues of the common law is its dynamic nature, and that makes it adaptable to the requirements of society at the time of its application in court. There's not a rule of the common law enforced today which has not evolved from some earlier rule of common law, gradually in some instances, more suddenly in others, leaving the common law of today, when compared with the common law of centuries ago, as different as day and night. The nature of the common law requires that each time a rule of law is applied, it be carefully scrutinized to make sure that the conditions and needs of the times have not so changed as to make further application of the instrument of injustice. And so it's not so much focused on some new rule or statute that was created, as it is focused on the times. It seems to me that with the common law, you could say that now, here we are 40 years later, and the times are different. And because the times are different, this particular interpretation no longer applies. They use this, a really good example with regards to marriage. And they basically say that at common law, a husband and wife were regarded as one. Sorry, at common law, a husband and wife were regarded as one because a metaphysical merger had taken place, and the legal existence of the wife had merged with that of the husband. Under this concept, either spouse was precluded from maintaining an action against the other for wrongful conduct, whether intentional or negligent. And then they go on to say that this artificial concept cannot be seriously defended today and is not compatible with our current society. So again, it's a little odd, but it does make sense. I feel like it kind of goes into that whole argument about one side, the conservative side, saying that the Constitution is the Constitution, and then the other side saying that the Constitution is a living document or something like that. Of course, we're not talking about the Constitution here, but it does kind of give off that vibe where, with respect to the common law, if the times change, the previous interpretation could change. But again, things may be different here, because with the Constitution, you're looking at a piece of paper with a list of text. With the common law, it's like there's these ancient ideas, these fuzzy ideas. Of course, I'm sure they were reduced to writing a long time ago, but it's not something that was created in America. It's something that existed prior to the United States, and we just adopted it as English common law. And so, in fact, there's many types of, I don't know if there's many, but I can think of one. There's one specific principle of the common law that the American colonists rejected, and that was the award of attorney fees to the prevailing party by default. So, of course, there's statutes now that allow that, but in the common law, they call it the American rule, actually. The American rule is that you do not recover attorney fees, even though that's what you would normally do under English common law. You do not do that in the United States. Again, that's just common law, and so you can override that with statutes and stuff like that. And it is overwritten in quite a whole slew of areas. At least in Nevada, there are statutes that allow the prevailing party to recover attorney fees, but they don't apply to all cases, and there's all kinds of complexities that go into that. So I hope that this gets people to understand what I'm trying to say is, if you are trying to figure out how to get around or bypass or change existing precedent that's binding, that's going to control your case in a direction you don't want it to go, typically losing, then you would need to look into the doctrine of stare decisis to figure out if that's something that you can do. And of course, I mentioned some pretty obvious ideas, which is things are changing, whether it's the times that change or whether it's the law that changed. These are things for you to look into. So I guess with that, I'm going to go ahead and end this video, and I will see you guys next time.